Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. Now, I have a great topic to talk to you about tonight, and it is going to be about renewing your 2-year permanent residence to the 10-year permanent residence without a spouse. But keep in mind that I am here to answer your U.S. immigration related questions as well. And it does not have to be related to the topic that I'm talking about. I am here every night at around 9 p.m. I'm on a little late today. I will be on Instagram and Facebook at around 9:30 or a little after 9:30, so you can always move over there to continue to ask your questions if you don't get to do that tonight. But I am monitoring the comments, so as soon as you have questions, go ahead and put your questions in the comments and I will answer. Now, renewing your 2-year to the 10-year. Now, that is one of those things that you have to remember to do once you obtain permanent residence. You may get the 2-year permanent residence. It's called the conditional permanent residence. And how you get that is if you have been married to your spouse for less than 2 years at the time you're approved for permanent residence, you're going to get a 2-year permanent residence. And it is sort of like a probationary period to make sure that you did enter the marriage in good faith. And so they want to watch you over the 2 years. When it comes on to around the 1 year and 9-month mark, it would be time to renew your permanent residence to the 10-year. But just like the first application, you have to submit evidence to show that you have continued to be a married couple. That means that you have to show evidence after you got your permanent residence. You wouldn't be showing the same evidence that you showed the first time you were applying. So that's important to know. And so it's very important to do that. But over the 2 years, sometimes things happen, and that happens with regular relationships. It does not last as long as you would hope, even though you enter the marriage with all the best intentions and all the best hopes for the future. And in a case like that, how do you move forward if you are separated from your spouse, if your spouse is refusing, if you don't trust your spouse to apply for your permanent residence with them, if you've divorced your spouse? How can you move forward to get your 10-year when the whole purpose of applying for renewing the 2-year to the 10-year is to prove that you had a bona fide marriage and to jointly file with your spouse? And there is an answer here. It is still possible to apply on your own. It is one of those, I think it's a big mistake by some individuals who are applying for the 10-year to think that at the point their spouse refuses to renew the 2-year to the 10-year, that all hope is lost. They're going to lose their status, and so they're going to end up without status, or they're going to have to return home. And that is not the case. You can apply for a waiver based on certain circumstances that occurred to cause maybe the end of the marriage, or certain circumstances that you may be facing. And so I'm going to elaborate on those. I want to take pause for a minute, though, to stress how important it is to evaluate your options from now. Even if you are currently with your spouse, it's time within the 2 years after you have obtained your permanent residence. You must make sure that you are collecting the evidence to show that you continue to be a bona fide couple. Even if you're going to be divorced or separated, it's still very important to maintain to show that you will continue to have a bona fide marriage. But in the case that you have been divorced, or you're facing mistreatment by the spouse, or you're going to experience extreme hardship if you lose that permanent resident status, then it's at that point you need to evaluate whether you can apply for permanent residence on your own and prepare for that. And it is very much possible. All right, so I'm going to take pause to answer questions. Let me remind you, on YouTube, I'm here to answer your immigration questions. So feel free to put those questions in the comments so that I may answer your questions. And then on TikTok, you know what the deal is. If you have been here before, you know that you're welcome to put your questions in the comments. Kalipu. How do you know when your process have started once documents are mailed? So before you even get the notices, you can check to see if you wrote a check to them. You can see if they cleared the check. In addition to that, there is a special form you can put on top of your documentation for them to notify you by text. And if you have the app, the USCIS app, and once they have initiated your processing of the application, they can send you notification that way as well. So what you will get is a receipt notice, and that receipt notice is going to confirm that they're currently processing your application. Great question. Go ahead, keep putting those questions in the comments while I finish up the topic of applying for permanent residence from your 2-year to your 10-year. So in this case, you've already gotten permanent residence, and now you're looking to apply for your 10-year after getting the 2-year. It's called removal of conditions application process, and it's usually done with the I-751 form. What documents does my beneficiary need to send to the National Visa Center if they are in Dominican Republic? So they're going to specify, the National Visa Center is going to specify what documents. Because I'm not the attorney on your case, I wouldn't be able to advise you specifically. But once you are logged into the National Visa Center, you're going to get a list of what you should be sending to them. So if I'm attending a funeral, how will that process go? And I lost my visa. So in some cases, if you have lost your visa and you need to attend the funeral of a close loved one, there are, and if you've lost it due to a violation of some sort or deportation or something of that nature, then you're going to have to look at the possibility of humanitarian parole as one option, or you may be able to get another emergency visa to be able to attend. But those are special processes that require a lot more evidence than the average visa application. So why did the USCIS send me another 24 months extension letter, but the previous one didn't expire? Because they're just updating it to show 24 months so that they don't have to do it. They don't want to wait for the 18 months, for your 18 months to expire before sending you. Now, 24 months means 24 months from the date of expiration on your card. It's not another 24 months after the 18 months. So they just want to extend it a little longer to allow for longer processing, just because it is taking an average of 2 years to process these cases. Can you get married in the United States on a B1, B2 visa and there apply for a green card? So Cubans, one, where that is possible, generally, I wouldn't be able to advise you whether you can do that. Just because I don't know what your circumstances are and I don't know what would be right for you, because I'm not your attorney. That's where a consultation is going to be very important. However, I have had clients who have been here and they have applied, they have gotten married and then ended up doing adjustment of status here. But whether that's going to work for you is going to depend on your circumstances, your current immigration status, your intentions coming in. How long have you been married? How long have you been in the United States? Have you already overstayed? And so it's very important to get a consultation. This is where I'm going to pause for a minute to tell you how to schedule a consultation. You can do that by going to the link in my profile or by going to stlawoffice.com And if you go to stlawoffice.com, you will be able to call. You'll be able to fill out a contact form, or you'll be able to do online chat. There is a scheduling coordinator who is available up until 11 p.m. Eastern time tonight to take your information. I applied for VAWA and it's been 1 year and 6 months. The only status update is fees were waived. So yes, everything is backed up and you're not the only one. These are taking a longer time to get decisions. Okay, so keep putting those questions in the comments. I am going to finish up the topic of applying for the renewing your 2-year to a 10-year, especially in cases where you don't have your spouse. Now, if you've been divorced from your spouse, they can no longer apply for you. If you have been mistreated by them, if mistreatment means if you've been verbally abused, emotionally abused, physically abused, financially abused, these could count as a way for you to apply without that abusive spouse, even if you're still married to them. Now, the requirements, if you've been divorced from your spouse and you are being mistreated, is that you still have to show that you entered the marriage in good faith. And that means that you still have to show evidence that your marriage was or is bona fide if you're still with them. These are confidential processes, and it means that they will not share that information with the spouse. So if they're abusive, once you have signed that you're applying on your own and you're applying for a waiver to apply on your own, you don't hide their 49th. You don't have to apply and give that spouse or ex-spouse any notifications or get permission or their signature on the application. That is what's so beneficial about this application. There is also the third option of extreme hardship. That one does not require that you show the bona fides of your marriage, but it does require a higher level of evidence to show that you will experience more hardships than the average if you were to lose your status. So what if I already filed, but we will get a divorce? So that's a great question, J. Mark. If you're applying for the 2-year to the 10-year and then you get divorced after you've gotten your 2-year permanent residence, you get divorced, or after you've applied jointly, you get a divorce, it is very important at that point that you update the USCIS about the divorce and apply for that waiver. With a waiver, you're still going to have to show that it was a bona fide marriage, but the divorce waiver is going to allow you to apply on your own. The waivers here that I'm talking about can be submitted at any time during the 90-day period that you have to apply for the 10-year, or even afterwards, meaning that if some changed circumstances happen, if the both of you get separated or even divorced during after you've jointly applied, you could apply for a waiver. If I'm a citizen and my son is under 18 years, do I need to file N600 or I-485 form if he's here? So in order for your son who's under 18 to derive citizenship from you, he first has to be lawfully a permanent resident, right? And so it's going to depend on whether he's here as a permanent resident, or if he has, or if he's not. If he's here just visiting, you would have to go through the permanent resident process first, to show that he has, to show that permanent resident status before he can become derive citizenship from you. So Red Phoenix, it's really going to depend, and that's where it's very important for you to schedule a consultation, because remember, the information I'm giving you is not personal legal advice, it's general information. And so you don't want to make mistakes with that, especially when it comes on to your son being here and his status. If we have a civil religion ceremony, will they still be able to come here with a fiancé visa? So Faisla, no. If they once you get married, it's not going to be a fiancé visa anymore. It's going to be a spouse visa. Now there is a K3 visa for spouses. But it is, the timeline for that is running on the same timeline for the spouse visa. But you would not be able, if this civil or religious ceremony is, hi there, Finn's mommy, it's nice to see you, and thanks for stopping by. Now, if this civil or religious ceremony is legally recognized as a marriage in wherever you did it, then in that case you're going to be a married couple and not it's not going to be an engagement. However, if it's not acceptable as an official wedding, then in that case you still may be able to apply for the fiancé visa. Faisla, that's where it's very important to schedule a consultation. All right, so I'm pretty much finished with the topic that I had to talk about, but our conversation doesn't have to end here. I'm going to be on Instagram in a quick minute, and you're welcome, Faisa, and I'm also going to be on Facebook. So I'm ST Law Office on Facebook, and then I am the immigration attorney, the same username as here, and in addition to that, my Instagram is linked to the TikTok, meaning you can click on the profile, there's the Instagram button, or you can go to the link in my bio and it's going to take you to the Instagram. So you can choose any one of those ways to be able to join me in a minute on Instagram. So it may be possible, yes, Lorraine, it may be possible to change your status from B1, B2 to an F1 status. But whether that's going to work for you is going to come down to your circumstances and a lot of different factors. So you need to schedule a consultation so we can talk more about your options. All right, so thanks so much for joining me. Now remember, the information I gave you is not personal legal advice, it's general information. So you should always schedule a consultation, seek personal legal advice before taking any action. You can join me in a minute on Instagram or Facebook at ST Law Office, where you can continue to ask the questions there. So I'll see you tomorrow at around 9 p.m. Eastern time, where we can continue to ask questions if I don't see you in a minute on Instagram or Facebook. So have a good night. I will see you in tomorrow or in a minute.